The 8-1 decision shaking the Second Amendment. A quiet emergency decision just dropped from the Supreme Court, and it may have just redrawn the battle lines for the Second Amendment and state gun rights. In an 8-1 vote, the court denied Missouri's request to protect its Second Amendment Preservation Act. But what happened behind that ruling is far from a loss. What's really at stake? It's not just Missouri. It's whether your state can protect your gun rights when Washington refuses to. This isn't a final ruling, it's a signal. And if you're a lawful gun owner, the consequences could be enormous. Before we begin, hit that like button and subscribe to Survival Lawline. These legal updates are moving fast, and missing one could cost you more than your rights. Now let's break down this emergency decision and what it means for all of us going forward. Part 1. Supreme Court shocks with 8-1 ruling. At the center of this legal storm is Missouri's Second Amendment Preservation Act, or SAPA. Passed in 2021, this law wasn't symbolic. It was aggressive. It declared that Missouri would not participate in enforcing any federal gun control measures that violated the Second Amendment. SAPA prohibited state and local officials from assisting federal gun law enforcement. It allowed citizens to sue any Missouri official who helped the federal government enforce unconstitutional gun laws. It was rooted in the principle of state sovereignty, the idea that the federal government cannot force states to carry out unjust mandates. The law made clear that Missouri viewed the Second Amendment as non-negotiable, no matter who controlled Congress or the White House. The Biden administration, unsurprisingly, took issue. A lawsuit was filed, and what followed was a legal journey that reached the highest court in America. SAPA became a test case not just for Missouri, but for every state with pro-Second Amendment values. Part 2. What this means for Missouri's SAPA law. The Biden DOJ wasted no time in targeting SAPA. Their lawsuit argued that Missouri's law interfered with federal supremacy, claiming states had no right to block or penalize cooperation with federal gun control. And early court rulings sided with them. A federal district court issued a universal injunction blocking the SAPA law entirely. The court declared SAPA unconstitutional under the Supremacy Clause of the Constitution. Missouri appealed, sending the case to the 8th Circuit Court of Appeals. But the appellate court doubled down, once again ruling in favor of the federal government. At this point, Missouri had two options: surrender or escalate the fight. They chose to go to the Supreme Court, filing an emergency request. Their goal wasn't just to save SAPA, it was to challenge the legal idea that states are helpless when federal agencies overstep their bounds. Part 3. DOJ's strange reversal explained. The Supreme Court responded with an 8-1 decision. On its face, it looks like a loss. But dig deeper, this wasn't a ruling on the merits of SAPA, it was a procedural emergency decision. And that subtle distinction could make all the difference in what comes next. The court denied Missouri's request for an emergency stay, keeping the injunction in place for now. Only Justice Clarence Thomas dissented, saying he would have granted the request. The denial was not a final ruling on whether SAPA is constitutional. The case now returns to lower courts for further review, where its actual legality will be tested in full. This denial simply means the Supreme Court wants more development, more facts, more rulings, and a more complete record before stepping in. And while SAPA remains blocked for now, the broader fight for Second Amendment protection is still alive. Part 4. Can states really ignore federal gun laws? Just as surprising as the court's decision was the stance taken by the Trump administration's Department of Justice. Many expected strong support for Missouri's law. Instead, their response was mixed, and that has left many Second Amendment supporters with questions. The Trump DOJ did not fully defend SAPA, agreeing with parts of the lower court ruling. They argued the prior judgment was too broad, but not entirely wrong. They offered a concession. If the court denied review, they would release some of the federal claims made under Biden's DOJ. Missouri used that very concession to argue that the emergency appeal should be denied, and the court agreed. For gun owners, this was a political and legal reality check. Even administrations that support gun rights may take narrow legal positions that prioritize procedure over principle. The fight to protect SAPA now returns to the states and to the grassroots. Part 5. Why the lower courts still matter. So what's next for the Second Amendment Preservation Act? The Supreme Court said no to emergency review, but that doesn't mean SAPA is dead. In fact, parts of it may still move forward in Missouri's lower courts, and the law itself may survive in a modified form. The case goes back to the district court, where the federal government will release part of the injunction. Missouri may pursue a narrower version of SAPA that avoids previous legal pitfalls. Other states may learn from Missouri's experience and draft stronger preservation laws. The court will now examine how SAPA could be implemented practically, not just in theory. This case isn't over. It's evolving, and in that evolution lies an opportunity to reshape SAPA into a model that can withstand judicial scrutiny while still defending state rights. That's the battle now, not just in courtrooms, but in state houses and on the ground. Part 6. State Sovereignty versus Federal Supremacy. At the core of this legal battle is a question that goes far beyond Missouri. Can states refuse to enforce federal gun control laws they view as unconstitutional? This is the fight between state sovereignty and federal supremacy, and SAPA has become the flashpoint. The Biden administration argued the Supremacy Clause gives federal law automatic priority. Missouri countered that the Constitution doesn't force states to help enforce federal law. This echoes the anti-commandeering doctrine, supported in past cases like Prince v. United States. That doctrine says federal authorities can enforce their own laws, but can't force states to help. If SAPA survives this legal storm, it could reestablish a key constitutional boundary, one where states are not passive bystanders, but active defenders of liberty when federal power overreaches. Part 7. Why other states are closely watching. Missouri is not alone. Other pro-Second Amendment states are watching this case like hawks because SAPA-style laws are spreading. From Texas to Florida, lawmakers want to know, can we follow Missouri's lead and protect our citizens against federal infringement? Texas passed similar legislation limiting state cooperation with federal gun control enforcement. Florida, Arkansas, and South Carolina have considered or introduced SAPA-style bills. A favorable ruling in Missouri could set a nationwide precedent, giving states legal cover to resist federal mandates. A loss could chill momentum and weaken future efforts to protect gun rights at the state level. This isn't just a Missouri issue anymore. It's a growing national movement, and the outcome of this case could either supercharge it or shut it down. Part 8. When 2A and 4A collide. With the emergency appeal denied, the case now heads back to the lower courts, starting with the district court and eventually returning to the 8th Circuit Court of Appeals, where this saga could take its most dramatic turn. The 8th Circuit originally ruled against SAPA, but acknowledged the law's structure was not inherently unconstitutional. They struck it down primarily because of its Second Amendment purpose, a legally shaky rationale. Now, with parts of the federal injunction being voluntarily withdrawn, the court must reevaluate its position. If Missouri narrows SAPA and removes weak points, the 8th Circuit might reverse course. This is where legal creativity and persistence will matter. A smarter version of SAPA could pass the constitutional test and become a blueprint for the rest of the country. Part 9. What gun owners need to know now. Whether you live in Missouri or 1,000 miles away, the outcome of this case could change how your state protects your rights. The Second Amendment Preservation Act isn't just a Missouri law. It's a bold legal experiment that could spread like wildfire if upheld. SAPA prevents state and local officials from enforcing federal gun control laws the state believes are unconstitutional. If upheld, it could allow states to block Biden or any future administration's gun regulations without needing federal permission. This would give you, the gun owner, a layer of protection closer to home with local law enforcement on your side. And if state officials violate SAPA, the law allows you to sue them directly for helping enforce anti-2A laws. In short, SAPA flips the script. Instead of gun owners always playing defense, it gives states and individuals the power to fight back. That's why gun owners in every state should be watching this case closely. It's about protecting your rights, right where you live. Part 10. The fight isn't over yet. Even though the Supreme Court just denied emergency review, this isn't the final word. The legal process is still unfolding, and there's a strong possibility that SAPA, or a refined version of it, will head back to the court. But this time it won't be for temporary relief. It will be for a full constitutional review. The current denial was only about emergency intervention, not the merits of the law itself. Once the district and appellate courts issue final rulings, Missouri could appeal again, and this time with complete legal arguments and a fully developed record. A future Supreme Court review could finally answer, can a state refuse to help enforce federal gun laws without violating the Constitution? And with a 6-3 conservative majority still seated, the final ruling could reshape the balance between state rights and federal authority. So, while the court stepped back for now, they may soon be forced to confront this issue head-on. The stakes are enormous, not just for Missouri, but for every state that wants to reclaim control over how gun laws are enforced. The battle just began. What we just witnessed wasn't a defeat. It was a delay, a pause before the next round in the most important legal fight for gun rights in a generation. The Supreme Court said no for now, but they didn't say never. SAPA's fate will be decided in the lower courts, but its spirit is alive across America. And every time a state stands up and says, we will not enforce unconstitutional laws, that spirit grows stronger. Subscribe to Survival Lawline for expert breakdowns like this one. Drop a comment below. Do you think SAPA laws are the future of state resistance? And hit that like button to push this story out to more Americans who care about their rights. The battle continues, but so does the movement.